I hope that you have already been informed at least about my name and therefore I need not introduce myself in any way. I also hope that even the topic has also been mentioned to you. Initially, I was thinking on some of the issues relating to Indian Constitution and constitutionalism, but then Pradyumna said that it would be better if I could speak on something relating to comparative constitutionalism. And it is in that context I decided that I would speak on judicial review in the common law world and the judicial review in the civil law world. Although of course both originated in the Western world, and therefore to that extent there is a commonality between the two. But the roots have been different and the basis also has been different because the understanding of law is different in the two systems. England and the rest of the Europe actually are close neighbors, and in fact the British constitutionalism and British legal history started with Norman conquest, and the William the Norman actually moved from from France to Normandy to England. So it is basically the continental rulers who established the present system in England. But then, so far as English law is concerned, its development took place differently. The reason being both political as well as natural. Political in the sense that so far as the Roman tradition is concerned, which prevailed on the continent, according to Roman tradition, the ruler is not supposed to interfere in the day-to-day disputes of the individuals or families. The ruler is supposed only to maintain peace and order in the society and let people be governed by their local customary laws. This is how the British system started with the idea of king's peace, that the only requirement to begin with was when the Norman kings came to England, that the people, so long as they don't disturb the king's peace, the king will not interfere in their matters. King's peace actually, to begin with, was confined to the palace or the household of the king, but slowly in course of time it started expanding, and even matters relating to decisions given by the feudal courts in the country, they were actually challenged or were brought before the king that the local rulers have given a wrong decision on a particular point. And this in a way made the king to take the steps necessary, because it could create actually disturbance to king's peace, and this way the king created some sort of court which ultimately became the king's court, which will maintain the law and order according to law. Now, this was one way. The other was that the matters were not only with respect to the disturbances, but matters were also relating to personal issues. To begin with, they did not disturb, but then personal issues also started coming to the king, and then another court or another set of judges had to be created by the king, which became the Court of Common Pleas. And simultaneously, therefore, the two courts for civil matters and the criminal matters started functioning, but King's Court was not only concerned with criminal matters, it was actually a general supervisory court in course of time. And any issues which created disturbance to the state, they had to be brought before the King's Court, which ultimately, of course, now it is called Queen's Court, is still within the High Court. And so far as the other court is concerned, that became the Common Law Court. But so far as the common law is concerned, that also developed from the local customs. And as the king or his officers, being French people, they pretended not to know the local customs. Therefore, they wanted, wherever a dispute arose with respect to property or any other issue, they actually said that the people from that locality must be consulted. And this consultation actually took the shape of jury system, that initially every matter on which some dispute has arisen, the local people will be asked to give their opinion. And this jury system was introduced both in criminal and civil matters, that if the local people say that it is something which is prohibited in that area, or it is something which is normally not done in that area, then it would be violation of law. And in this fashion, slowly, these matters, though of course there are big details, but I don't want to go into them for the simple reason that the main issue is of judicial review. We have to come to that. These decisions then became actually static, in the sense that once a decision has been given on an issue by the King's Court or by the Court of Common Pleas, that became a precedent. And therefore, if in future any issue similar to that arose, the court did not necessarily require the need of jury, and they said, already we have decided that this is the law. Now you tell us whether there is any violation of this law by these people. And to that extent only the juries function, that in those circumstances where there is any violation. But this gave birth to the theory of precedent, and it is how slowly, in course of time, all customary law was converted into state law. And that is why the English law basically is called as the public law, that is made by the rulers, and not the private law or made by the people, because all customary practices were converted, and then later on it was said that now all customs have been converted into law, therefore no question can be raised based on customary practices. As a result of that, in England, for example, there are no customary laws, only laws are state laws. But the law which initially arose as public law did not draw that distinction which is drawn in the civil law countries. In civil law countries for a long time, the Roman law actually, which was the primary law and was considered to be the system, a golden era so far as the legal system is concerned, that was introduced from 11th century onwards. That is, the corpus juris civilis, which was actually consolidated Roman law during the time of almost the last king, King Justinian, in the 6th century. That became the basis, and it became a book law rather than the law based on custom or based on state commands, rather a book law, and the church people actually took the responsibility of evolving it. The first beginning was made in Bologna in Italy, and from there actually the people from all over Europe started coming to study Roman law and introduce the principles in their systems. But this law actually was customary law, and the local customs also actually were interpreted according to the methods which were given in the principles of Roman law, which was exegetical, that is through argumentative practices. It was developed and consolidated in different countries. So Roman law actually became the foundation of all the laws in Germany, along with the customary laws which prevailed. And in this way, the law acquired the character of being a private law. That basically the law is customary practices of the people and is not made by the state. It is only later on, when the state came into existence from 13th century onwards, the modern state, and finally a division was created between religion and state. That's another issue in which we need not go. But the basic premise of civil law system is that it is basically private law. Law is not made by the state, rather law grows with the people, and that is what Savigny's thesis you may have read, but this was also Henry May's thesis also, that the law grows like language with the people, and it is not made by the state. But slowly, when the states started becoming powerful and regulating people, at that point of time, the state also started exercising certain powers. And those powers had to be exercised in the beginning according to the whims of the rulers, but in course of time, resentments were expressed by the people, and as a result of that, it became necessary that this law also must be, this practice must also be regulated by some norms. And it is since then that the idea of public law developed in those countries. France actually gave it a full shape by way of revolution in 1779, and that way a clear distinction was drawn between the public law and the private law. Private law was introduced in the Napoleon Civil Code, which is a complete exhaustive book of law, and which says that after this, in all civil matters, there would be no source of law, only the civil code is the source of law. So the consolidation of law in civil code was of course a creation of the state, but it was actually a collection of the customary practices that existed at that time were given shape of law. But when this revolution took place, at that time it was against the state, and the idea of liberty, equality and fraternity for all citizens that was developed, and therefore it became necessary that the state must take the responsibility of ensuring these rights of the people in future. It is in this fashion that the state took the responsibility of ensuring that it also acts according to law and not according to whims. And active measures have to be taken for the purpose of ensuring that the people and the state both are governed by the state, by the law, and therefore state officials cannot, nor the king can act arbitrarily according to his will. Now this created the necessity of making similar arrangements as the common law system had already made, more than in England, in United States, where the revolution took place a few years before, in 1775, and then later on, finally in 1789, the present constitution was made. Now the constitution was a written constitution. In France, unfortunately, because there was not a similar tradition as the tradition of state subject to law had developed in the light of the evolution of law in England, which was inherited by the people who dominated in the colonies which were established in United States. That law that common law became the basis of the law in the United States, and therefore they actually could easily make a constitution and follow that constitution. So far as the European countries or France was concerned, they could not systematize so quickly a constitutional arrangement, and as a matter of fact, dictatorship to some extent under Napoleon continued until after his death, when slowly the process of establishing constitutions started, and the present constitution is called the Constitution of Fifth Republic. It is only in the Constitution of Fifth Republic that for the first time the idea of having a constitutional court and constitutional review was introduced. Otherwise, the conception was that the National Assembly is the representative of people, and no judge and no one else can sit over the judgment of the people. Therefore, whatever the National Assembly decides, that should be the final conclusion. But in the Constitution of the Fifth Republic in 1958, provision was introduced for a constitutional council. Now, but already the distinction between two laws had been created in France and in all the continental countries, that the laws are private as well as public laws. Two types of laws, that the laws which regulate the state matters and the laws which regulate the private matters. It's not easy to draw a clear-cut distinction, and no clear-cut test actually has been laid down as to what is public law and what is private law, but definitely a distinction exists, and that exists much more scientifically and stoutly so far as the civil law countries are concerned. That distinction exists in England and all countries that have been England's colonies, not only United States, Canada and Australia, even in India and the neighboring countries wherever the Britishers have ruled, that this kind of clear-cut distinction between public law and private law doesn't exist, and basically the law is public law, that is the state-made law. But at the same time, the conception of public law was not developed the way it has been developed in the civil law countries or in the European countries, where the clear distinction between public law matters or state matters, like dharma and rajdharma, for example, that kind of distinction was not created in England, but it was created in Europe. And it is on that basis that the idea of dualism of law actually arose, that there is not, law is not of one kind, law is of two kinds. The law which binds the state and its officials, and the law which binds the common people. These are the two categories. The law which is followed by common people and binds them, that is one category of law, and the law which binds the state is another category of law. In common law countries, the theory of monism, that law is one, there cannot be separation between the public law and the private law, and therefore it will be considered as one law to be decided by the same courts. And as a result of that, therefore, in common law countries, the same courts which decide the private matters, they also decide the public law matters, and no distinction is drawn between public law and private law. No distinction is drawn between judges who handle public law matters and the judges who handle private law matters. But so far as Europe is concerned, it applied that principle of distinction between public law and private law also to international law, that and the theory of dualism with respect to international law is also propounded in Europe, and therefore so far as international law is concerned, generally it is part of the law of most of the European countries. Automatically, it doesn't require necessarily a treaty or anything, and some of the constitutions very specifically say that the principles of international law will be binding on the state, and German constitution particularly makes that provision in Article 24 of the basic law. So this dualism of law gave birth to a different system than the one which existed or exists in common law countries. As a result of that, when the judicial review was established in the form of review of administrative actions in England, basically that function was performed by the King's Court, which actually was not a public law court but a court in general. It is another matter that there was a division between courts, but that division was also abolished in 1875 to 79, and now the High Court has replaced all these courts, and only one common court, that is the High Court. But within High Court also that division exists between the Common Pleas, King's Bench, Queen's Bench. The equity courts have also merged into that, but Chancery remains known and separate for the people. And so separate divisions in some form, historical basis, continues to exist, though it is now the High Court. The King's Court, however, took action, and by 15th century, it had been established that the government officials also have to act according to law, and if they don't act according to law, the courts may declare their actions invalid. They cannot even exercise their discretionary powers arbitrarily. But so far as the review of the legislative actions was concerned, this principle could not be applied to the laws of parliament even in England, that the legislative actions, whether they can be challenged on the ground that they violate the some kind of law, some principles of law, that could not be established in England. And as a result of that, when the written constitution of United States came for consideration in Marbury versus Madison, there were strong arguments that the constitution was not made to control the legislation. That is, the Judiciary Act, which gave the jurisdiction to the Supreme Court, which the Supreme Court read was not consistent with Article 3 jurisdiction of the Supreme Court. Therefore, it violated the Constitution, and it is on that basis that the Marbury versus Madison case was decided. And it was decided on the basis again of law, that we have to either accept that the Constitution is law or that it is not law. If the Constitution is law, then it is an obligation of the court to apply that law. And in the categories of law, Constitution definitely is the highest law, and for that reason, therefore, that law will prevail over all other laws. And it is on that basis that the principle of judicial review was established. The principle of judicial review, therefore, in short, actually, is the power of the courts to determine whether the acts of the legislature or executive are consistent with the constitution or constitutional principles. But since in all countries now the constitutions have been written, therefore, and particularly so far as the Western world is concerned, all countries have well-established constitutions. Therefore, it is with respect to the written constitution that that principle applies. That whether the actions of the executive or of the legislatures, that is the two organs or other organs of the state or main organs of the state which exercise power, are consistent with the constitutional provisions. So judicial review actually is not only review of laws, it is also review of the executive powers. But it is with reference to not the administrative law aspect, which normally is to see whether the administration has acted according to the law under which it has been created. The principle of judicial review is confined to the acts of the so-called executive, that is the executive government, whether it has taken an action which is not consistent with the constitution. And similarly, so far as legislature is concerned, whether the legislature has enacted a law which is not consistent with the constitution. If the court comes to the conclusion that it is not consistent with the constitution, then Marbury versus Madison established that court is under an obligation to say what is the law of the country. And in that exercise, you have to say either the law of the constitution is the highest law or the law made by the legislature is the highest law. But logically, since the constitution has been made by the people and with the purpose that it should bind all the organs which have been created under it, therefore the laws must be consistent with the constitution. Now, then, so far as civil law countries are concerned, this idea though of course established in United States in the beginning of the 19th century, 1803 is the Marbury versus Madison. But in Europe it did not percolate for a long time. For the first time in Germany, in its draft constitution, which is called as the Frankfurter Constitution or Frankfurt Constitution of 1848, there the idea of judicial review was introduced, but since that constitution itself failed, and the next constitution was made only in 1919, but not very clearly. The idea was introduced in the constitution of 1919 also. So ultimately, the idea of judicial review was finally introduced after the present constitution of Germany, which was made in the same year, a few months earlier than our constitution, that is in the year of 1949. We finished on 26 November 1949, while the Germans finished on 23rd May 1949. It is in that constitution that for the first time they could introduce. But for that a background had already been created, and the background was created by Hans Kelsen, who for the first time, while writing the Constitution of Austria in 1920, in that constitution could provide for a constitutional court. But this idea was very different from the idea in United States or other common law countries. How was it different? Primarily it was different that in the common law countries there is no court separately as a constitutional court. It is the ordinary courts of law which also decide constitutional matters. And in this respect, even about India, the position is that even the district courts, though they say that we are not entitled, but there is nothing in law which says they are not entitled. Neither the constitution says, nor any law says that they cannot decide constitutional matters. Maybe just they don't want to exercise that power, perhaps thinking that this responsibility belongs only to the high courts or the Supreme Court. Otherwise, the CRPC and CPC only put the restriction on the district courts that if a legislation, not regulation or anything, if a legislation or an act is challenged in the lower court on the ground that it is inconsistent with the Constitution, and this matter has not been decided already by the High Court or by the Supreme Court, then only the lower court can send that matter by way of reference to the High Court. And not actually court can refer, it is the party concerned which has to make a request for reference, and the order for reference has to come from the High Court and not by that court itself. So it's only in those cases, and that is only reference. So after deciding the constitutional issue relating to the validity of the law, it may come back to the district court, and district court may also decide. So the same courts from lower court to the highest court can decide the constitutional courts, and this is exactly the position so far as the United States is concerned. All the laws first are actually challenged in the district courts of United States or in the district courts of respective states, and they then ultimately by way of certiorari come from the states to the Supreme Court, and within the United States courts by way of appeal also they may come to the Supreme Court. So it is in this way the process remains uniform process, that the same courts decide constitutional matters which also decide the general matters, And this is one of the factors which existed so far as United States and the practice of judicial review is concerned. The same was introduced in the Constitution of Australia as well as earlier under the Constitution of Canada. But Kelsen did not follow that rule, and he said that public law is of different nature. And our judges at the normal judiciary are not competent to decide public law matters. And for that reason it is necessary that a special court must be created for deciding public law matters or constitutional matters, and for that reason a separate court must be created. And so this was one of the reasons that he gave, that the judges are career judges in European countries. They join at the lowest level and go up to the highest level. While in the common law countries, judges at the higher courts or constitutional courts normally are appointed from amongst the senior lawyers who have established their practice and who have so far been fighting against the state, who have developed some ideas of liberty of the individual, and who have developed the idea of how the laws are challenged before the courts. Therefore, their position is different. So this was the argument which Kelsen took, that since our judges, the normal judges, are not competent to decide constitutional matters, it is better to create a specialist court for that purpose, which will decide only constitutional matters and nothing else, and that would be the exclusive court. No other court can take up constitutional issues. And secondly, the other reason he said was that in the United States or common law world, there is a theory of precedent, and therefore if a decision has been given by the highest court of the country, that decision becomes binding throughout the country, not only against the federal government but also against the state governments, and everywhere that becomes the law. In Europe there is no theory of precedent. Any court actually can differ from the decision of the highest court in that branch or in that branch of public law or private law. And this way it will create a chaos if different courts decide or interpret constitution differently. Therefore, these two justifications he gave for establishing separate courts for the purpose of deciding constitutional courts, which should be the exclusive court for the purpose of those issues. And since Austria is a small country, it could easily be implemented. But later on that idea actually worked well, and so after the Second World War, when liberty was given to the Germans to make their constitution, the Germans actually worked on that idea and made improvement even on what Austria had done or any other constitution had done in Europe, and they established a special constitutional court, and not which actually became the most powerful court. At the moment it is considered to be the most powerful court, not only in Europe but throughout the world. It is said that the kind of powers which the Constitutional Court of Germany can exercise, other courts cannot exercise. So wider powers have been given to that court, and its model, this is the American authors also, like Tushman for example, they accept this, that the German model is becoming popular, and more countries which are making their constitutions are following the German model, and among them the most prominent is the South Africa, which has created a separate constitutional court, not following the common law model, but following the civil system, civil law model, which is based on the idea of the German Constitutional Court. But the German Constitutional Court is also special in another respect, and it is special that it is a twin court, that the 16 judges of that court are divided into two divisions, which are called as the Senates, Senate 1 and Senate 2. So first Senate consists of 8 judges, and it decides matters relating to individual rights. The it decides the matters other than the individual rights, and the second Senate decides the matters relating to individual rights, primarily matters relating to the rights of the people. The two Senates don't interact with each other. Their jurisdictions are separate. Only when a conflict of jurisdiction arises that the entire court sits together, otherwise their decisions are separate, independent from each other. The judges are not transferable from one court to another court. The other feature of the court is that the judges are appointed for a definite period. Their appointment is for 12 years, and no reappointment is made. So after 12 years, every judge has to change. Normally, half of the judges are university professors who have never actually practiced or have sat as judges, but they are appointed to the Constitutional Court, and the rest, other half, are judges from the other courts, means highest courts, but only 3 is the limit. Not more than 3 shall be taken from the highest federal courts, from those 3 judges. But the others, again, may be lawyers, public figures with law degree, but all of them have to be lawyers, means having the law qualifications. In this way this stream works. The power of the courts are wider than the power of the courts in the common law countries. In the common law countries, normally, as the American Constitution provides, cases and controversies are decided. That is, when there is a real case that the government has either taken an action against an individual which is against the Constitution, or the affected the power of another branch of the government, that branch may come to the Supreme Court or to the appropriate court, or when the right of an individual is violated, then only a matter can be brought to the court. So there must be actual case or controversy, and unless there is an actual case or controversy, the courts normally refuse to entertain a matter. Even in the public interest litigation, you have to convert it into a case. That is, there is a plaintiff and there is a defendant. But so far as the German courts and the courts in the civil law countries are concerned, for them, the other feature is that there need not be a case or controversy. The government is also entitled to take any constitutional issue to the Constitutional Court for its opinion. Now, to begin with, the government started with that practice, but when that practice was often repeated, the court actually put a restriction, and the restriction was that it will decide such issues only when the government takes the gives the guarantee that it will be binding on it. If there is that assurance, then only the court will give its opinion, otherwise it will refuse to give its opinion. Therefore, its opinions are as much constitutionally binding as any other. Similarly, so far as the advisory opinion of the Supreme Court is concerned, though of course it is different from the other common law countries, but the Supreme Court also, perhaps not in the very beginning in Delhi Law's case, took that guarantee, but ever since then the court always asks the Attorney General, we will decide this advisory matter only if you take the guarantee that you will follow whatever advice we give. And in this way the process has been going on. Moreover, the court can also refuse to give advisory opinion. But so far as the German position is concerned, it is not actually advisory opinion. It is a jurisdiction which is assigned to the court that the certain number of the members of the legislature can bring a matter before the court. Certain number of government ministers may brought of the states as well as of the center may bring a matter before the Constitutional Court, and therefore it is a special jurisdiction which is generally the case in the most of the European countries. But in this respect, so far as the German Constitutional Court is concerned, it has acquired a special respect. So far as France is concerned, there is also a Constitutional Court provided in the, it is called as the Constitutional Council in the Constitution of 1858. But the difference is that most of the judges in that court, firstly the appointment process is also different, that there are 9 judges in that court, and out of these 9, 3 are appointed by the President of France, 3 are appointed by the upper house of the National Assembly, and 3 are appointed by the lower house of the Assembly, and thus the 9 judges are appointed, and hardly there is a lawyer in them. Mostly they are the politicians, mature politicians, non-controversial politicians who are considered to be well aware of the public law issues. And therefore, most of the matters also which are referred to this council are referred by the government. The individual does not have the right to go to the Constitutional Council. And the Constitutional Council actually is empowered to decide the validity of a proposed law. It cannot decide the validity of a law which has already been passed by the National Assembly. Then it cannot be questioned in the Constitutional Court. Through some method, recently the Constitutional Court has created some kind of judicial review of such laws, in the sense that when subordinate legislation is made under those laws, then the question arises whether that subordinate legislation is authorized by the main legislation or not, and it is in that process that the court may decide the scope of the national laws or laws made by the by Parliament. It is only to that limited extent, but so far as the German court is concerned, it gives jurisdiction both to certain authorities of the state as well as to the private individual. The final remark, because I would like to leave some time for you. I don't know whether it is left or not. The final remark is that so far as the judicial review is concerned, generally the position with respect to judicial review is that the presumption is that judges act independently and they don't bother what the politicians do. But the analysis of judicial review by the Americans as well as with respect to the European countries is that that is not actually a fact. The judges, while they are reviewing the validity of the legislation or of the executive, then they take certain considerations into mind. And one of the considerations is whether the government, executive or the legislature, would actually abide by their decision or not. And if it is not likely to abide, then the court also take into consideration whether the people would resent against the government or not if our decision is not enforced by the government. Like for example in what is that Jallikattu, Tamil Nadu issue, earlier the Supreme Court had said it is violation of the Cruelty to Animals Act. Now they have declined to invalidate that law without giving any reason, but knowing that not only Tamil Nadu people but also the present government is supporting, and therefore if we give our decision, there is a possibility that it may not be enforced, and that would actually subject the court to ridicule, and therefore to avoid that, the courts normally take into account the public opinion. Now, and the third point relates to, yes, the democratic aspect, that the courts always take into account, that is, whether their decision would generally be appreciated by the people or not. And it is in this way that the argument which is made against the judges, that how can judges actually invalidate decisions of the democratically elected people, that argument may not be correct, for the simple reason that on the analysis of the cases which have been decided from the by the courts from the earliest times, including Marbury versus Madison, the court has given relief only in those cases where they know that the decision will be enforced, and it will also be, its enforcement would be approved by and large by the people, and if they give a reverse decision, the people also may not support the court, and for that reason it is appropriate that they must modify their decision or keep it for the time being as it is. Could be one of the reasons that they did not actually look back into that Hindutva aspect in the recently deciding large court decision. Also to uphold section 123 of the Representation of People's Act, because otherwise the whole wish of Parliament that certain people should be made incompetent would be actually affected. This is how, therefore, the courts are not actually, judicial review is not as undemocratic as people generally think. With these remarks, I end up by saying that so far as the judiciary is concerned, it is also a democratic institution promoting constitutionalism, as also the people's elected representatives do. With that, although of course it is a very wide sketch, not a detailed picture either of Germany or any other constitution, but maybe I hope there are some issues which perhaps you have been introduced for the first time. If there are any questions, please feel free to ask. Okay, you are looking towards my hair.
So they're looking towards the younger you.
Okay. No, that is true. I am getting old now. Voice has changed.
So for any questions or comments, the mic will come to you.
Hello. Yes, anyone? No reaction? Yes.
So I was just wondering that as you were recounting this distinction between, why Kelsen suggested a constitutional court.
Yes.
If you recollect, there was at one point where the Indian Supreme Court was also talking in terms of getting divided as one Supreme Court of Appeal and a constitutional court.
Yeah.
Do you think we should have taken that line?
It is still under consideration.
I know.
It was the Law Commission under Justice Matthew, which gave a report for separate constitutional court. I don't know why. Maybe some of you have heard the name of Dieter Conrad, who helped in establishing the doctrine of basic structure in our constitution. When I mentioned to him, he was of the opinion that it is not a good idea. The common law in this respect is still better arrangement than the civil law system, and we need not or you need not follow our system. There may be certain qualitative difference, but he said that as a basic principle that all questions of law will be decided by the courts, not only specific questions, only constitutional questions. This is actually, he says, it is a very beautiful principle of common law, because in civil law system, courts have only that much jurisdiction as is given to them. But in common law, the courts have as much jurisdiction as they decide to have. And that power with the courts, he said, better protects a constitutional system than a system where the court is created for specific purposes. That is what his view was. He didn't explain in detail, but this is what he felt. And therefore, it is still doubtful. People say that the quality of the judgments will improve. But the court may inside make some arrangements, but whether that would be made through constitutional amendment, that I am not sure whether that would be a right step.
I have a small follow-up question basically
Yes.
on the same.
Yes.
In the sense of that, the way you recounted that entire history to us, you spoke about the fact of how in the common law system,
Yeah.
in a manner, in a progressive manner, people's customs became part of state law.
Yes, yes.
In countries like ours,
Yes.
it's not really been that way.
Yeah.
So, and consequently, do you think we have, though we are considered to be a common law country,
Oh.
have we sort of done that serious engagement with customary practices that happened in the inception of the common law? I mean, say in England, where the way in which the common law evolved, we've not really had a similar history. And much more freezing has happened of people's view. And I think the Jalika 2 controversy or the others are demonstrating to us this.
Yes.
So I thought maybe a little elaboration on that.
I entirely hold the same view as you are holding, that we simply assume that we are a common law country, but we have never seriously considered whether we are a common law country, in the sense in which common law has developed in England and has been taken to other colonies. So far as colonies like Australia and Canada are concerned, they are basically colonies of British people. And therefore, whatever law they took with them, it is those people who are administering it, and so problem doesn't arise. But so far as a country, huge country like India is, where the Britishers were effectively for less than 100 years, 1858 to 1947, basically 90 years or less than 90 years, whether that arrangement which developed in common law world in nearly 900 years or so, whether that development could take place in 90 years, that is doubtful. And since this question has been arising for a number of years in my mind, we have finally started working on it. At the moment, 4 researchers are working with me on this project, that whether our assumptions that we are common law country are the correct assumptions, and whether it is the reason that the rule of law is so weak in this country. A rule of law is violated not only by the ordinary citizen, but it is violated by law persons and maybe even by the judges of the Supreme Court. Therefore, why it is happening, why it is like that, the reason may be that the spirit of common law has not become part of our legal system. How far that is true, we have to see, because apparently it seems that for reasons of convenience, that the existing system could not be easily replaced, we were not prepared with some replacement. Therefore, the Law Commission thought it best that let it continue. But its continuance actually has not been successful. Once a law of Parliament of England is passed, it is the last word for the people, and only deviants actually violate it. But so far as India is concerned, firstly, many people would not even know what that law is, and even after they know, they would not care for it, and this not caring is not part of only of ordinary people, but of lawyers, everyone. And this is because it has not been internalized. Yes, please. Yes, please.
Thank you, sir, for the lecture. Sir, I just wanted to know more about like why, when it comes to constitutional issues, district level judges are not entertaining it. Is it because, except those sections which you mentioned, is it because they are not aware of it, or they are aware of the consequences if there may be? Just wanted to know like what's your...
Initially, Article 228 and 229 actually, they were read, which defines the powers of the high courts. They were read as if the constitutional issues, because it is with reference, with respect to references by the lower courts, that the lower courts may refer a matter to the High Court on a constitutional matter which the High Court has not decided or even the Supreme Court has not decided, then only it can refer. But if there is a decision on that issue already of the High Court or of the Supreme Court, the lower court need not refer this to the High Court. The Constitution doesn't authorize actually, but this has been taken from the very beginning by the constitutional teachers also, that is those who teach the Constitution. They also teach that the power of deciding constitutional matters belong only to the High Courts and the Supreme Court, and we have now adopted a terminology, constitutional courts, appointment of judges of constitutional courts, as if only High Courts and the Supreme Court are the constitutional courts, the other courts are not. So it is in this way I think a notion and a practice has developed. Somebody there, yes?
At the back. I can identify the two hands there or one?
Good afternoon, sir. I'm a second year student. I'm just curious to know, you said that in the German Constitutional Code, generally it's the professors who are being elevated to that status. And in India, it's generally the senior advocates, and after the practice, they are being elevated to the status of the judges. So, sir, what do you think is the rationale behind appointment of the professors and not the other judges in the Constitutional Court? And how this thing helps in efficacious working of the German Constitutional Court?
Yeah, the reason could be that most of the professors in the universities, if they are professors of public law, then their opinions are continuously sought by the higher courts in Germany on legal issues. The entire case is sent to the professor to give his opinion as to what is the law in this matter. So they are familiar with cases and the opinions that must be given on that. So they are not actually totally ignorant about either the process of the courts and the way the courts actually decide matters. Moreover, the courts consider the opinions of the professors as the binding opinions, and normally they will decide the case accordingly. Now, so far as we are concerned, of course, we have highly qualified professors, and from time to time, issue has been raised that why they are not appointed. But that kind of experience which professors in Germany have, our professors don't have. There is no communication between courts and the professors or law departments in this country, which is very common so far as the European. Actually, they are already, professors are already honorary judges in the appellate courts of different jurisdictions. There are 5 different jurisdictions in Germany, for example, apart from the constitutional jurisdiction. And these judges, these professors are attached to one court or another court, and they are invited even to sit with the judges in the court to decide a matter. And as you might be knowing, the process of the courts is not open like here, that every small matter also has to be discussed before the public. There, unless there is a matter where the court considers it necessary that there must be an open hearing, there are no open hearings. The court prepares their decisions not in the absence of parties, but in the absence of general public. This is, the practice is entirely different, and professors participate in that. So the professors are fully familiar the way the courts work and the way the judgments are written. That is the difference between the two systems.
I just wanted to ask something. Are there other hands? Okay, Lakshana and Varun, and afterwards.
And even in United States, it's not very common. Only some examples have been, like Frankfurter, we give the example. But Frankfurter also, before becoming judge, for many years he was working in the government. It's because of his maybe affinity to the president and the government officials that he became the judge and proved to be a successful judge. But most of them have been at some, many of them have been at some point, like Justice Ginsburg was my professor in Columbia. I attended her classes on sex-based discrimination, and later on she became a judge, first in the New York Supreme Court and then in the Supreme Court of the United States.
A very good afternoon, sir.
Yes, please.
Hello.
Yeah.
Very good afternoon, sir. Sir, I wanted to ask that as a closing remark, you said that judiciary, which is not composed democratically, many times functions in a democratic fashion.
Yes.
Similarly, at many times, Parliament, which though is composed in a democratic fashion, many times is accused of not functioning in a democratic way. Like there are several non-democratic factors like the party policies and the interest group approach, which affect the functioning of the Parliament. So the kind of governance that we are seeing is that a body which is composed in a democratic fashion is functioning in a non-democratic way, whereas a body which is not composed democratically is functioning in democratic ways to some extent. So I wanted to ask that what kind of governance are we heading to? With this kind of trends, what kind of governance are we heading to? Are we heading from a completely democratic society which is presumed to be utopian state to a quasi-democratic areas wherein a body is either composed or functioning in a democratic fashion or?
Yeah, democracy actually is not perfect anywhere.
That's what 2 cheers.
including England or United States or civil law countries, and therefore some defects are always there, and that's why, at least to keep it within constitutional framework, the constitutional courts are created. Yes, please. Adesh.
You talked about the democratization of judicial review,
Yeah.
and the courts now there seems to be a trend that the courts are taking into consideration popular or public sentiment, like the Judicial incident happened and the referee was deciding it finally.
Yeah.
Is this taking into consideration the popular or public sentiment to decide a case? Is it democratization of judicial review, or is it succumbing to the popular pressure?
Not necessarily, but that whether it is stumbling to popular pressure, but popular pressure in what form? Actually, popular pressure falls more on legislators or the executive than on the judges. Of course, they are supposed to uphold the constitution, and irrespective of what the legislature unanimously decided with respect to NJAC amendment and the act, the court invalidated it, because the court also has to protect the constitutional structure, that the court was expected to remain independent of the legislature and the executive as an independent body. And also perhaps they calculated that public will not actually oppose this decision in general. And you may say that public is ignorant, but that is the fact that many people in their heart felt that this kind of superiority to legislature or executive in respect of appointment of judges in a situation in which we work may not be actually healthy for the constitution. And that's why there is not, I don't think that there was much resentment against that decision. Kishan Gupta is another matter because he held the brief for a JSC amendment and all that. But otherwise, people in general have supported the decision.
So since we have limited time, can we collect questions? Whoever else wants to ask. I think there were 2 hands I saw. Right. So instead of maybe answering one by one, can we just collect 2 questions?
Okay, I think you do it, John.
Because they have classes also.
Yes.
So my question is the context of personal laws in India.
Yes.
Considering that there's an opinion that these laws don't fall under Article 13 of the Constitution, do you feel that judicial review when it comes to personal laws in India is justified with respect to Part 3?
So far I have been holding the view that they don't fall. Because neither they are customary law, nor they are statutory law. Therefore, Article 13 definition of law doesn't cover them. Maybe I am wrong, but this has been my view so far of the interpretation of Article 13. So that is my short answer to that question.
Sir, my submission, sir, but 13 include customs and usages that have the force of law within territory of India.
Yeah, but these are not customs. These are not customs. Personal laws are not customs.
Good afternoon, sir. I'm an LLM student here.
Yes, please.
So my question is, how do you reconcile 2 principles of public law? For instance, parliamentary sovereignty and judicial review. Judicial review with respect to legislative actions. How do you reconcile in one democratic setup both parliamentary sovereignty on one hand and judicial review of legislative actions on the other?
Yeah, that is what, of course, these questions have been arising from time to time. But as we have already spoken, that democracy does not mean whatever parliament decides. Democracy is actually a good example that Aristotle actually divided constitutions into 6 categories. And among them, there was a democratic constitution. And another category was constitutional democracy, or a democratic constitution, constitutional government, democratic constitutional government. Now, a purely democratic government is not necessarily a constitutional government. So, the democracy in that sense of raising hands is controlled by constitution. And we have to see whether the principles which have been laid down in the constitution by the people to be observed forever by the people unless that those principles are changed by the same process by which the constitution was made. They have to be upheld and respected. So for that reason, judicial review is necessary as part of democratic process itself. Because democracy is not without constitution. Democracy is a creation of the constitution, and therefore it is constitutional democracy. It has to act according to constitution.
So maybe we can take the last question. There was one hand is a bother there. I think Lakshana, you had your hand up?
Yeah.
Yes, please.
That will be the last question. The mic.
Hello.
Yes.
I wanted to ask you if you could share with us your thoughts on the ongoing BCCI issue. I want to ask you if you could share with us your thoughts on the BCCI issue, the ongoing dispute with respect to the legal status of BCCI, and what it means for constitutional law.
I didn't.
So she's asking about the BCCI issue as to what's your opinion on that?
BCCI?
Yeah, the court kind of controlling the cricket control board and so forth.
Okay. Actually, when the BCCI case was first decided and the court led by Santosh Hegde held that these matters are not public law matters and therefore no writ can be issued against BCCIS and therefore it can't fall under Article 226 and they refused to interfere. At that time I wrote a critique of that decision, that it is a wrong decision because a body need not be a statutory body to be a public body, and a body like BCCI which holds so much wealth and also controls so much sentiments of the people cannot be considered to be a private body, and against which remedy is not available in the Supreme Court or in the High Court by way of writ petition. So I would support the decision, the last decision of the Supreme Court, and also to some extent, of course, about that I am doubtful whether judges are the best administrators. But judges may make right decisions about who could be the administrators, and now they have made a decision, and apparently it seems that the current decision is a right decision. Apparently we all accept that the right kind of people have been put there. I don't know whether they will work rightly or not, that's a different matter. Okay, thank you for giving me this opportunity.
So sir, on behalf of NALSAR, I say an official thank you because since we started late, we didn't do a formal introduction, but Professor